Good afternoon and welcome to the Irwin Mitchell English Employment and Immigration Law and International Perspective webinar this Wednesday afternoon. Thank you for joining us. My name is Sibylle Steiner. I am a partner at Irwin Mitchell in the employment team, and I also head the Irwin Mitchell German desk. I am today joined by my colleague Hugo Bittencourt, who is an associate in our immigration team, and he and I will try to explain in an hour interesting and important issues both under employment law and immigration law in the UK. We have a lot of material to go through, and our slides are quite detailed. We will not be explaining necessarily everything that is on the slide, but you will be sent the slides afterwards so that you can have a look at that as well. If you have any questions, if you could please put them in the chat, we will try and answer them during the webinar. But if not, we are very happy to get in contact with you afterwards. So it would be very helpful if you could leave your name and the email address so that we can get in contact with you. If you have any comments or suggestions, any feedback with regard to the webinar, then please let us know. I think if we could go to the next slide, there should be some information with regard to that. There is the QR code there. So if you want to scan that, that's great. You will have seen that on the slides introducing Hugo and me. There are also QR codes. Again, please contact us or please get in contact with us via the QR code. We are both on LinkedIn. We put a lot of information of new developments onto LinkedIn. So if you are connected with us, you will be the first to know. So let's have a quick look at the agenda, what we are going to cover today. The first part is the employment part. As I mentioned before, I'll give you a quick overview of sort of crucial, important UK employment laws. Then we will be looking at the Employment Rights Bill, which is going to introduce fundamental changes to English employment law. And last but by no means least, I'll say a few words about AI and employment law and the issues that we see with regard to that at the moment. Then Hugo will take over and he will talk about sponsorship licenses, the skilled worker route, right to work checks, penalties, very important to know about those. And then last but not least, what are permitted activities that would allow people to come to the UK as a standard visitor. So let's start with the employment law. I thought that one of the best starting points would be to look at employment status. So as some of you no doubt will already be aware, there are three types of status in the UK. We have what is called an employee. We have what is called someone who is self-employed. And then in the middle of that, some sort of some would say weird hybrid status of a worker. And to understand what status an individual has who works for a company, an organization, is of utmost importance because the status determines the rights. So how does one distinguish between these three options? As you can see on the slide there, the employee is someone who must provide a personal service. There must be what is called mutuality of obligation, and the employer must have control over the employee, and the contractual terms must be consistent with employee status. On the other hand, a self-employed person, there is no requirement of or accept work, no requirement for personal service, so one can send a substitute. The individual can decide when and how to work and also can provide services for other organizations. What the parties call the arrangement is utterly irrelevant. What is relevant is how this is lived in practice. And the worker there in the middle, as you can see from the slide, there are also similar requirements or conditions that we have for the employment relationship. Namely, it must be an individual who must work under a contract. There must be mutual obligations when working. So the important word there is when. Personal service must be provided, but there is not necessarily, there is no obligation to offer or accept work. I will leave you with those definitions here. We are very happy to explain that further on a factual basis, because every case is different. So let us have a look. Let's see, we've done the analysis and we've got to the conclusion that the individual working is an employee. So let's now have a look on the next slide as to what sort of typical rights an employee has. So as you can see, that is a long list. That's obviously not an exhaustive list, but there is a right not to be unfairly dismissed, and I'll say a bit more about that in a minute. The right to request flexible working, then there are family-related leave and rights, right to receive statutory sick pay and the national minimum wage, redundancy pay. There has to be a minimum notice when it comes to terminating the employment. An employee can't be discriminated against or is protected from less favorable treatment where there is a fixed term contract. There is protection from discrimination. The employee has a right to paid holiday and rest breaks, whistleblowing protection, and protection from unauthorized deduction from wages. As I said at the beginning, the Employment Rights Bill will substantially change employee protections and entitlements, and we will have a bit of a closer look at what sort of changes are on the horizon a bit later in the webinar. So for the time being, let's just leave that list as it is and have a look on the next slide to see what rights a worker has. And if you can compare those rights with the ones we just looked at in relation to the employee rights, you will see some of them are the same, namely the right for paid holiday or rest breaks, protection from discrimination, protection from less favorable treatment, part-time working, no unauthorized deduction from wages, national minimum wage, and also whistleblowing protection. Again, there are some changes on the way under the Employment Rights Bill, in particular with regard to zero-hour workers. And again, we will look at that in a little bit more detail in a few slides' time. If we could go to the next slide, please. As I have mentioned, both with regard to workers and employees, those types of individuals who work under those arrangements are entitled to receive the national minimum wage. The rates are usually reviewed in November, and then new rates will apply from each April. And since the 1st of April this year, the national minimum wage for apprentices and those under 18 years is, as on the slide, £7.55. Then for 18 to 20-year-old, £10, and the national living wage, that is the minimum wage payable to workers aged 21 or over, is £12.21 per hour. So are these age bands likely to change? The government says that it is committed to removing these age bands for adults because they call them discriminatory age bands. And the government has therefore asked the Low Pay Commission to consider how to achieve this. That's done by way of consultation. And the consultation is taking place with a view to making recommendations for the 18 to 20-year-old rate from April next year, so 2026. The Low Pay Commission say that from April 2026, it is working on a projected range of £12.55 to £12.86 per hour for the national living wage, i.e. payable to those aged 21 or over. And it estimates that this rate is likely to increase by 4.1% to £12.71. So that would be an extra 50 pence per hour. The Fair Work Agency is something that the Employment Rights Bill will create. And what this Fair Work Agency will do is to bring together the existing functions of HMRC in relation to the national minimum wage, the Employment Agency Standards Inspectorate, and the Gangmasters and Labour Abuse Authority. This agency will be established again in April 2026, and it will have particular enforcement powers and enforcement functions. Now, what exactly, when these powers will be brought into force, again, is not entirely clear. So watch this space. But the policy intention behind the Fair Working Agency is that there is a single place for workers and employers to turn to for help. And it will not just be there to use enforcement powers against employers, but it will also aim to support businesses in complying with the law. And over time, the Fair Work Agency is also expected to take on enforcement of a much wider range of employment laws. So not just national minimum wage, but a much wider range. If we could move to the next slide, please. There has been a call for evidence with regard to unpaid internships. As I just said in relation to the previous slide, where an intern falls within the definition of a worker, then these interns would need to be paid. If an intern does not fall within the definition of worker, then they do not need to be paid the national minimum wage. There is an exception for interns. There is an exception for the national minimum wage with regard to students, and I will get to that after I finish the intern slide. With regard to interns, again, the government is very concerned that too many interns are unpaid, that there has been a lot of misuse with regard to interns, and the government will want to close any possible risks and loopholes that businesses might have used up until now. The call for evidence closed on the 9th of October. So that consultation is finished, and we will need to wait and see what the government will put into law based on these consultations. Now, I have mentioned just now the question of international or students at UK higher education. There is an exemption to the payment of the national minimum wage with regard to students at UK higher education places. That can be UK students or international students where there isn't a requirement to have an internship as part of the higher education course. Unfortunately, that exemption does not apply with regard to students who study at a university that is not in the UK. There is case law with regard to that. The judge in the case that decided that in fact said that it is discriminatory, that this exemption does not apply to students who study at universities outside the UK, but that nevertheless that was the law. So students studying a course at a UK university where an internship is part of the course are exempt from national minimum wage. Students studying at a university outside the UK who would like to do an internship here in the UK as part of the course are not exempt. If we could go to the next slide, please. So let's have a look at the right not to be unfairly dismissed. That, at the moment, is a right that only kicks in relatively late into the employment relationship, namely after an employee has been employed for 2 years, although technically it is 1 year and 51 weeks. That is an important distinction. Prior to those 2 years or 1 year, 51 weeks employment, an employee can only rely on reasons that would entitle the employee to claim automatic unfair dismissal. So, for example, where an employee can argue that they were dismissed for discriminatory reasons or because they blew the whistle. So where there is a right not to be unfairly dismissed, there has to be a fair reason. And in particular, a fair procedure has to be followed, and the decision to dismiss must not have been made before the procedure is finished. This unfair dismissal right will be changed considerably under the Employment Rights Bill, namely in the way that the right not to be unfairly dismissed will become a day one right. So every employee will be protected against an unfair dismissal from day one. What does that mean for the employer? Obviously, one has to be much more stringent and detailed and careful when it comes to employing employees. There will be a lighter touch procedure for employers during what will be called a statutory probationary period. How long that is likely to be is not clear at the moment, but we are expecting that to be around 9 months. But even in those 9 months probationary period, it will not be possible to let someone go without a fair reason, without a fair procedure. Some reason and a lighter touch procedure will still have to be followed. What that will look like, we do not know yet at this point. We are waiting for regulations to deal with that. If we could have a look at the next slide, please. That is a brief summary of protection from discrimination. That is covered by the Equality Act here, and that Equality Act 2010 prohibits discrimination in respect of protected characteristics, which I have listed on the slide there. And the protection is against direct discrimination, indirect discrimination, harassment, and victimization. And also important to note that with regard to disability discrimination, there is a duty on employers to make reasonable adjustments for employees with a disability. If we could have a look at the next slide now, please. Sexual harassment and third-party harassment. Now, you may know that since October 2024, so almost a year ago now, employers have had a duty to take reasonable steps to prevent sexual harassment by workers and third parties. Now, what is sexual harassment? Is unwanted conduct of a sexual nature which has the purpose or the effect of violating a worker's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So one of the important words there is has the effect. So what we often see in this context is that people say, oh, it is just banter, we didn't mean it. But the fact that it wasn't meant is irrelevant, because what is relevant here is what effect the unwanted conduct has. The obligations for the employer are quite strict. So it's not possible to just say, oh, well, we'll send an email round just prior to the Christmas party to tell people to behave. What, as an employer, one does need to do is to start off doing a risk assessment to be able to analyze and understand where the risks of such harassment occurring are, and then to take steps in order to minimize those risks. That also involves training of managers, training of employees, policies that are not just in a drawer, but are actually lived. And only after an employer can show that those steps have been taken, or the other way around, if an employer cannot show that those steps have been taken, it will be extremely difficult to file a defense against any claim that an employee may have with regard to sexual harassment. Also important is that this does apply to third-party harassment, so harassment by, say, suppliers, for example, potentially harassment at a business event, at a trade fair, and so on. And what we advise our clients in that regard is to try and have contractual arrangements with suppliers that put the supplier and others under the obligation to ensure that their employees do not harass our employees, so the company's employees. Next slide, please. Employment tribunals. So most employment claims, obviously no one will have a claim at the employment tribunal because of all the steps that business will take in order to prevent that from happening. But of course, that is in an ideal world. And in fact, the employment tribunals here are absolutely overburdened with work and with cases. We have matters here where hearings are listed in 2 years' time. So it's taking a long, long time for the tribunals to be able to deal with this. The time limit at the moment for most claims to be brought is 3 months. But the Employment Rights Bill will extend that to 6 months. So employees will have much longer to put forward a claim against the employer. Before that can be done, an employee must commence what is called early conciliation with ACAS. ACAS is also totally overworked. Commencing early conciliation stops the limitation clock, and the early conciliation time is 6 weeks. Only this morning I had a call with ACAS on a matter where ACAS contacted us after that 6 weeks period had gone because I simply didn't have the time to deal with it beforehand. It doesn't mean that the matter cannot be settled, but again, there is bottleneck in the proceedings, and that's something also to bear in mind. If we could now please look quickly at the future law reform before I hand over to Hugo. If we could have a look at the next slide. I've already mentioned a few of the changes that are likely to be on the horizon, and there are a few more listed there. Again, that's not all of them, but that's sort of the important ones to look at. We've dealt with the unfair dismissal situation already. Fire and rehire is also an important one because those new rules suggest that it would be automatically unfair to fire an employee and rehire on a different contract unless the employer faces extreme financial difficulties and changes that are unavoidable. Now, when that was put forward as a suggestion, that caused a huge uproar, and there were amendments published in July this year, and those are now being debated, and those significantly amend this fire and rehire prohibition. What is now proposed is that a dismissal will be automatically unfair only where an employer seeks to vary an employee's contract to make a restricted variation and the employee doesn't agree. What is a restricted variation? That sort of changes relating to pay, hours, holiday, and anything further specified in regulations. 0-hour contracts, there is going to be a right introduced for an employee to ask for a guaranteed number of hours if they have worked that number of hours in a particular reference period. Again, no details are clear yet, so we will need to wait and see. Statutory sick pay will become, again, a day one right. At the moment, there is a waiting period of 3 days, and the employer's duty to prevent party harassment will be extended from taking reasonable steps to all reasonable steps. Also, an important proposal is to reform the use of non-disclosure agreements. So that is an agreement for an employee to keep certain scenarios and so on and facts confidential. Again, that's a watch this space one, and again, it's something that employers weren't necessarily too happy about. There are also going to be changes on collective consultation. I'm not going to go into that in any detail now. If you have any questions with regard to that, please let us know. I think we can, on the next slides, you will just have a timeline. I'm not going to take you through that, but have a look at that to see when these various changes are likely to come into force. On the next slide, you will see what is being consulted about and when. And on the next slide, please, how to prepare. Well, obviously, to keep up with the development, enhance the recruitment processes. I mentioned that already in the context of the unfair dismissal day one right. Train managers, carry out audits, have a look at contracts and policies and risk assessments now. We can assist you with all of that. On the next few slides, you will find some information. I think we will go past the AI. You will find information about our back to basics trainings, other information pieces that we can offer, our employment events, podcasts, and so on. And in particular, I didn't deal with the AI slide because I'm looking at time. We do have a webinar that is just dealing with AI in the workforce, and that webinar will take place on the 5th of November. So if you would like to register for that, please do so. So, having absolutely raced through employment law in England and Wales in 30 minutes, I'm now handing over to Hugo for immigration law. Thank you.
Thank you, Sibylla. Good afternoon to everyone that could join us today. We're very happy to have you here. I will start the immigration section by discussing sponsorship. Fantastic. So what is sponsorship? Sponsorship is the process via which a UK business is granted permission by the government to sponsor and employ a foreign national. Now, since Brexit, that classification of foreign nationals includes anyone who is not a British or Irish national, which obviously is a large pool of people. It is a cornerstone of the UK's points-based system, and it is designed to ensure that migration is controlled, compliant, and aligned with national interests. Now, for those who might not know what the points-based system is, within several routes within the UK immigration system, in order to apply for certain visas or to obtain permissions under certain categories, you have to accumulate a minimum number of points to become eligible for that particular route. So, for instance, the skilled worker route, one there is looking into applying for that particular visa, they would have to collect at least 50 points under that route to be able to qualify. Now, the way in which you collect those points is by satisfying different requirements that particularly apply to that route, and by collecting those points, you can then obtain that visa. Now, sponsorship is a privilege, not a right. The Home Office's position in respect of that is that a business might, in theory, tick all of the technical boxes. So they might meet all of the requirements, the eligibility, the validity requirements, everything in theory, and still potentially not be granted sponsor license holder status. The reason being that beyond satisfying the technical elements of that application, the Home Office wants to see that the business will play a part in ensuring that immigration and the immigration system as a whole is not being abused. And that goes beyond just immigration law. That will cover employment law, that will cover tax law. The businesses need to observe wider UK law that goes beyond immigration. So it's a privilege, not a right. There is no guarantee that the business will be granted status, even if in theory they tick all of the technical element boxes. Next slide, please. Right, so this is a quick overview of the three main stages of a sponsorship process. So the first stage is obviously obtaining a sponsor license if the business does not hold one just yet. Once the license is in place, then the business will need to issue a certificate of sponsorship. So what that is a document that is generated by the business and issued by the government through their sponsorship management system. It is a document that confirms all of the details about that sponsorship. So you confirm the details of the individual. It will confirm the details of the role itself, the salary, job title, job description, and so on. So that document needs to be issued by the business first. Once that is in place, then the individual will be in a position to prepare and submit their application for, let's say, a skilled worker visa, but that applies to any work visas as a whole category. Next slide, please. All right. So once the sponsor license is in place, the Home Office will want to see that the business has all of the measures and systems in place to comply with their duties and responsibilities as a sponsor. Now, the individuals that will perform certain roles in order to comply with those duties are listed on the slide. They vary in levels of responsibilities and obligations, but I'll quickly go through the main ones just so you can understand what would be expected of the business. So the first role is the role of the authorizing officer. That will normally be the most senior person within the business that is involved to some extent in recruitment. So that will normally be a HR director, manager, something along those lines. It doesn't have to be, but it normally will be. I normally say to my clients that that is the face of the license. And the reason for that is whenever the Home Office decides to audit the business, if they do decide to do so, they will contact the authorizing officer, and that will be the person responsible for showing the Home Office where the documents are, who the people, who is who basically, who does which jobs, and they need to be able to demonstrate that the business is on top of its responsibilities. So that's the authorizing officer. Now, the key contact is the main person to be, obviously, it's quite self-explanatory. They'll be in contact with the Home Office mainly through the application process. So once the business decides we're going to apply for sponsor license, If there are any needs for additional documents or evidence information, they will contact the key contact, and that will be the person liaising with the Home Office in that instance. And then the last category is level 1 and level 2 users. They are the people who would be doing the day-to-day admin tasks that come with a sponsorship. Those can be, for instance, requesting and assigning the certificates of sponsorship that I mentioned just earlier, reporting any changes to the Home Office, whether those are in relation to the individuals or the company itself. And anything that has to be done by the business when it comes to admin work, any compliance duties will be reported through the system, and that is done by the level 1 and level 2 users. Fantastic, brilliant. Can we move on to the next slide? Right, so compliance. I think there are a couple of bullet points missing there. Oh, there we go, perfect. So compliance, this is really, really important. And there are 3 main categories that we need to adhere as a sponsor license holder. So the first one is reporting, second one is record keeping, and third one is monitoring. We'll have separate slides for each of those so we can understand what they actually mean in practice. But it's incredibly important that as a business, we understand what is expected of us, because if we do not comply, not only, as I mentioned a bit earlier, with UK immigration law, but wider UK law as well, and the Home Office finds that we've breached our duties, we may see penalties being imposed on the business, and that can range from suspension of the license, revocation of the license, civil penalties, and even in worst case scenarios, but this is really rare, worst case scenario, imprisonment. So it's a really serious matter, and compliance is really, really important for anyone that is considering holding a license. So if we move on to the next slide, we'll discuss reporting duties first. There are 2 main categories when it comes to reporting duties. The first one relates to changes of workers' circumstances, and then the second one relates to changes relating to the business itself. So on the left-hand side of the slide, you will see that the events that take place and require reporting from the business's side in respect of the workers, those need to be reported within 10 working days of the event taking place. So there is a list there. We can see that if the individual does not start working for you within the time frame that is expected when you decided to sponsor them, that needs to be reported. If they are absent from work without your permission, that needs to be reported. If the worker decides to leave the business, or if we decide to let them go, that needs to be reported. And the easy way of remembering this is anything that has to do with the worker and changes of their role, job, and personal details, those need to be reported within 10 working days. Now, when it comes to the business, any changes of name of the business, location, size of the business, if that means we stop being a small sponsor and then become a medium or large sponsor, anything that has to do with the business itself, those need to be reported within 20 working days from the event taking place. Those are really, really important, and the reporting is done through the sponsorship management system by the level 1 or level 2 users, as discussed a bit earlier today. Next slide, please. Record keeping. Right, so when it comes to record keeping, the businesses must keep all records relating to the migrant workers for the duration of the employment plus 2 years. So duration of the employment, an additional 2 years after that, then by that point, you can let go of those documents. And you'll see from the list that those can be kept either in paper form or electronic form. The Home Office does not have an issue with either, but we have to be aware that those need to be accessible at all times. So if we are audited by the Home Office, and that will be the function of the authorizing officer to show them where these documents are, who the employees are, what they're doing, they need to be readily accessible. If the Home Office comes to the conclusion that there isn't a system in place and the documents are all over the place, or the business doesn't really know where the documents are, that will be an issue. We must obviously comply with GDPR standards, and we must keep consent forms as well when there are children under the age of 18 that are being employed. Right, next slide, please. Monitoring. So, as I mentioned, we cannot think about UK immigration law only. When we obtain the status of a sponsor license holder, the threshold or the scrutiny is even higher than it would be for a regular employer that might not necessarily hold that status. So the Home Office will hold us to a higher standard, and we have to observe wider UK law. Obviously, when it comes to immigration, very often that will we'll touch upon employment law, we'll touch upon tax law, but we're not limited to those. It's wider UK law in general. Now, there are a couple of examples there. So when it comes to UK employment law, national minimum wage, which Sibylla discussed a bit earlier today, working time regulations, pension schemes, and so on. So I'll leave you to go through that list in your spare time. But what we have to bear in mind is holding a sponsor license does not mean we only have to worry about immigration law. We have to observe all areas of law in the UK, so even higher standards than you would normally be expected to. Next slide, please. Consequences of non-compliance. Right. So there are two main, consequences if the Home Office finds that the business has breached its conditions as a sponsor. The first one is suspension of the license, which we have on this slide. If the license is suspended, we will basically be locked out of the system. So we won't be able to issue any new certificates of sponsorship, which by default means we cannot sponsor any new migrant workers. Now, for the workers that have been sponsored and are sponsored currently, they can continue to work for the business. Their sponsorship is not terminated automatically from that, but we're basically locked out and we are not permitted to sponsor any new people. If the license is suspended, that is suspended in all of the routes that we may have been granted permission under. So it doesn't matter whether the issue came from a breach of duty in relation to a skilled worker. If we have a global business mobility license, that also gets suspended. So it is quite severe. And then the third point is just in respect of the current workers, as I mentioned, they can continue to work. So we can move on to the revocation slide. Brilliant. Now, revocation is obviously more severe, and the offences that might lead to revocation are split into three different categories. So those are the instances where, number one, the Home Office will revoke your license and there is no discussion. Number two, where they normally will. And number three, where they might revoke the license. Obviously, the degrees of breaches will vary here depending on the category that we're talking about. But if the breach falls under the first category, there is nothing you can do about it. If they find that you've taken an action that falls under that category, the license will be revoked, and that is that. Once the license has been revoked, a very serious consequence from that, obviously apart from the license being revoked itself, that is really not great for the business, but even beyond that, we have to think of the workers themselves, the workers that are being sponsored. What happens to them is their sponsorship is terminated. So what will happen is the Home Office will issue a curtailment letter, which will be sent to these workers to say, hi, so your employer's license has been terminated. Unfortunately, that means that your visa is being curtailed, and normally the Home Office will grant these people 60 days to either find a new sponsor, which we can all appreciate that is not an easy task to achieve within 60 days. Um, Alternatively, they may switch into a different visa category. So let's say they switch into a family route visa or a student visa or whatnot. They are permitted to do that. If all of that fails, by the end of that 60-day window, they would be required to leave the UK. So it can have a very significant impact on migrant workers' lives if revocations take place. Um, there is no right of appeal against the decision to revoke. Like I mentioned, if they find that you've taken an action that falls under the first category, they will revoke it. There is no contesting that. And once revocation has taken place, you are not permitted to reapply for a new license for 12 months. So there is a cooling off period. You have to wait for a year. Once that year has passed, then at that stage you can reapply, and a decision will be made based on the merits of that particular application. Next slide, please. Right, so skilled worker route now. That is the most common worker, well, I guess for workers that are coming into the UK, that is the most common work visa route in the UK. As I mentioned earlier, you have to collect the points because it is part of the points-based system in the country. And the main advantage of this route is that once you've been in the UK as a skilled worker for 5 continuous years, you become eligible for settlement in the UK. So at that stage, you can apply for indefinite leave to remain, which is permanent residence in the UK, which means you don't need to be sponsored anymore, and you can live in the UK indefinitely. Now, there is a massive discussion happening at the moment on this particular topic. The government is considering increasing that time frame from 5 years to 10 years. There will be a consultation on this very soon. We don't know whether that is actually entering into force or not. But as you can imagine, that would make the process a lot more lengthy for most people because that is doubling the time that they would have to be in the UK until they reach that settlement status in the country. Right, next slide, please. So we've got the key criteria for those who wish to apply for a skilled worker visa. The first one, obviously, is that the business that is looking to sponsor you must hold a sponsor license, and it must be a valid license. Point number 2 is that the job that is being proposed satisfies the job level requirement. So they need to be at the appropriate RQF level, which is set by the ONS. Then we have the salary level requirement. Depending on the type of role that the individual would be performing, there are different thresholds that we need to satisfy as a business when we offer that position. And then we have the English language requirement. There are exceptions to this rule. So if you are above the age of 65, you're exempt. If you are a national of certain countries where the Home Office will consider that English is their first language, so the US, Canada, Australia, you're also exempt from that requirement. But everyone else, they might not be exempt or might not have a degree from the UK. Will probably have to satisfy that through other means, such as English tests and whatnot. And then the last requirement is the TB and criminal record certificate. That is very specific. It depends on the type of role that you are performing in the UK and your country of origin. That will determine whether those would apply to you or not. So if we move on to the next one, please. Yeah. So we had big changes, which I'm sure most of you would have seen on the news in July 2025. I'm going to discuss a couple of the big ones here that have made the whole process a lot more difficult for most people. So the first big change is in respect of the job level requirement. Up until July 2025, the RQF level expected was at level 3 and above. So anyone that would be offered a role at RQF level 3 and above could potentially be sponsored. Since then, that has been raised to RQF level 6, which is equivalent to a degree level and above. And as you can imagine, there is lots of jobs out there that might not necessarily be at degree level and above, but that would, businesses would benefit from if they could sponsor individuals for those particular roles. When that entered into force in July, the report that came out suggested or indicated that roughly 180 occupations were scrapped from the list of eligible occupations. So that's 180 roles or general occupations that can no longer be sponsored. As you can imagine, that affects lots of different businesses across multiple industries, and that is just part of the government's goal to reduce net migration. The second big change was in respect of the salary level requirement. The general threshold was increased from £38,700 a year to £41,700 a year. That is obviously a significant increase, and it makes it more difficult for businesses to afford sponsoring individuals. And then the last big change is in respect of the English language requirement. This has not entered into force yet, but the government is again studying or thinking of raising the bar for the skilled worker to satisfy the English language requirement no longer at level B1, but at level B2, and for dependents to now also have to satisfy that requirement at level A1. So those were big changes, and they've definitely made the process a bit more difficult for businesses. Right, next slide, please. Job at an appropriate skill level, basically what I've just discussed. If the role is not at degree level and above, RQF level 6, they can no longer be sponsored. Now, there are exceptions to this rule, and the exceptions are the 3 bullet points that we have there on slide. The first one is if the role is on the immigration salary list, then even if it is below RQF level 6, the role can be sponsored still. The second one is if the role is on the temporary shortage list, which is basically the list that the Home Office put together to acknowledge that some industries are in high demand and we just don't have enough people to fill in those roles. So they are basically allowing an exception for those particular areas. And then if the role is in that list, even if it's below RQF level 6, they can still be sponsored. And then the last exemption is in respect of those that had already been granted permission as a skilled worker before the changes in July 2025. It wouldn't be fair to expect businesses to then suddenly change the roles and the salaries for people who are already sponsored and employed by them. So those who have had visas prior to that date, they can still rely on the previous rules. Next slide, please. And then the salary level requirement, as I mentioned, depending on the SOC code that the role falls under, so which type of eligible occupation that we are discussing here, is this a solicitor, is this a doctor, is this an engineer? All of those different occupations will have different salary levels that would be expected for that particular occupation. So we have to assess what that threshold would be for each individual case. And it can be quite confusing to understand what the rules actually mean, because if you actually check appendix eligible occupations, you will see that there is lots of different tables that will apply to different people in different circumstances. So if you ever need help with the assessment of the job level requirement or the salary level requirement, we would be more than happy to assist with those. Right, next slide, please. Okay, so we're now coming on to right to work checks. This is incredibly important. All employers in the UK, and this does not relate only to sponsor license holders, this is everyone. Anyone who is an employer in the UK must conduct right to work checks. before they allow their employees to start working for their businesses, and that is so they can establish a statutory excuse against liability for a civil penalty. What that means is just so they don't get fined, basically, if it is found that that individual did not have the right to work in the UK. So there are three main ones, and then a fourth one, which serves as a last resort, methods to complete that right to work check. They will apply, those categories will apply to different people in different circumstances. So it's really important that we establish and that we know, right, manual right to work checks, who does that apply to? Online right to work checks, who does that apply to? We can't pick and choose. They are designed for specific needs, for specific circumstances. If it is found that the business has not conducted right to work checks properly, or we haven't done them at all, then civil penalties can be applied to the business. The current rates are that for a first offence, the business will be fined at £45,000 per illegal worker. And for repeat offences, 60 grand per illegal worker. As you can imagine, if we're talking multiple workers here, it could become quite a hefty fine here for the business. I've had clients in the past that were in a tricky position where the fine could be looking at £2 million. So as you can imagine, that might completely destroy a business. So we have to be really careful with right to work checks, and we will quickly go through the four main categories here. This is just a quick overview of the three main steps when it comes to right to work checks for British and Irish nationals. So really important here, manual right to work checks, which means getting the physical document and looking at the document, can only be done at this day and age for British and Irish nationals. Anyone who's not British or Irish cannot rely on the manual right to work check. As you can see, the first step is to obtain that document. Normally, we're considering passports here mainly, but it doesn't have to be. There is a list of documents that are acceptable. Normally, passport. We look at the passport, we check that the document is genuine and presented by the correct person. So we basically look at that document and assess whether the person that we see on screen or in person actually looks like that person from the passport. So we're checking that the document is genuine, and then we make a copy of that document in a way that cannot be altered, and then we'll sign and date it and confirm that the right to work check was completed. Like I mentioned earlier today, record keeping. We need to keep that document for the duration of the employment plus 2 years once that person has left the business. So manual right to work checks, British and Irish nationals only. Now, online right to work checks on the next slide, that will be for everyone else. Everyone else who's not a British or Irish national will have to conduct an online right to work check. What that is the Home Office's toolkit via which the employee can obtain their right to work share code, which is a 9-digit share code. They can send that to you, and then you as the employer, you can go onto the Home Office's website, insert the details of the employee, that will normally be the date of birth, and the share code, and then generate a document that will confirm this person is permitted to work in the UK. These are the conditions of their permission to work. And then the business at that stage would obtain statutory excuse, and they will be protected against any civil penalties. So online right to work checks for everyone else that is not a British or Irish national. And then we move on to the third option, which is the IDSP. So it's the Identity Service Provider. This is the same, basically, it's the same as the online right to work check, but it's when the business decides to outsource the responsibility of doing the right to work check. If the business is really busy and you say, actually, Hugo, we just don't have the capacity to do that ourselves, we can outsource that to a third party. However, we have to be really careful here, because outsourcing that to a third party, even if they are approved by the Home Office, does not exempt us from the responsibility of that right to work check. So what does that mean? if that service provider does not conduct the right to work check in the correct manner, or let's say they choose the incorrect method for that particular individual, or they choose the correct method, but they don't follow the procedure as it should have been done, we are still liable as a business. It's still our responsibility to check that what they've done is correct. So whether that is a good trade-off or not for the business, that is obviously the business's decision. But in my view, if it is that you have to then double check what they are doing, you might as well do it yourselves and make sure that that is being conducted appropriately. And then the last resort is the employment checking service. So if we go back, yes, brilliant, thank you. The last resort is the employment checking service. Now, we can only use this last resort if everything else fails. If the online right to work check can be done, we have to do that. We can't use the ECS. If the manual right to work check can be done, we have to use that. The ECS check will only apply in situations where, number one, there is an ongoing appeal or a pending visa application where the person has overstayed and their visa has obviously expired by that stage, or if there are technical issues with the Home Office's website, and then you have no option but to use that. But remember, it's a last resort only if everything else fails. Right, so if we move on to the next slide, I will leave you to go through the list of common mistakes here because I've basically touched upon them, but they will basically be things like conducting the incorrect type of right to work check or using the incorrect document and things like that. So I'll leave you to go through and I'm conscious of time, so I'll leave you to go through that list. If you have any questions as well in respect of any of that, you can contact us after the webinar and we can have a little chat. And then if we move on to the last slide on the penalties, again, we've discussed this already. Civil penalties of 45 grand for first offences, 60 grand for repeat offences. And this is the very serious one that I mentioned a bit earlier today, which is quite severe and quite scary. But I will explain why you should not worry too much. Someone may face a criminal conviction if it is found that an illegal worker was working for the business. Now, this would only happen in the scenario where you know that that individual does not have the right to work in the UK and you still choose to employ them anyways. If it is a scenario where the incorrect right to work check was conducted or you forgot to conduct that right to work check, a criminal conviction or a prosecution in that respect would not take place. So for the criminal sphere, that would only concern those who know that that individual cannot work in the country and they still choose to employ them anyways. And then obviously for company directors, they can be disqualified in that respect. But that's it when it comes to penalties. Civil penalties, criminal penalties if you're found to have known that that individual cannot work in the country and you chose to do it anyways. And then directors can be disqualified as well. Fantastic. And then if we move on to the standard visitor permitted activities. Now, it's very common, obviously, for international businesses to, and especially since Brexit, when we look at European businesses, we have so many questions and inquiries about individuals and employees that need to come to the UK to do certain business activities. And the very common question is, can they come to the UK as a visitor, or do we need to obtain a work visa for them to come? How do we go about that? The answer to that, as with most things in law, I suppose, is it depends. I've set the most common types of permitted activities on the slide, and we'll go through them very quickly before we can wrap up. But the overall understanding is that someone can only come to the UK as a standard visitor for short-term purposes. So they can't come if they're thinking of staying for years on end. And they cannot work and they cannot settle in the country. And this is really important because some of the permitted activities may give the indication, or the terminology might make you think that means that a person can work in the UK, but they cannot. That is really, really important. If work is taking place in the country, that cannot happen under the standard visitor route. Now, the most common types of permitted activities that you may do in the country as a visitor. PA2, tourism and leisure. So you can come and visit friends, family, go on a holiday, come for a recreational course for up to 30 days. That is all fine. PA4, general business activities. So someone can come into the UK to attend meetings, conferences, seminars, interviews, to negotiate and sign deals and contracts. That is also permitted. To inspect sites, they can go on sites. Sites visits and inspections are permitted. To gather information for their employment overseas. And these are only examples. On appendix permitted activities, you would be able to see the full list, but I just chose the most common ones here, just by way of illustration. Then PA5, intercorporate activities. So an employee of an overseas-based company may advise and consult, troubleshoot, provide training, and share skills and knowledge on a specific internal project with UK employees of the same corporate group. So it has to be on a specific project. It can't just be on a general sense. We'll send this person and then they will teach these people how to do X, Y, and Z. It has to be for a specific internal project. Let's say HR is doing training on HR. That's fine, but it needs to be a specific project. PA7, that will be for manufacture and supply of goods in the UK. That will be where a company overseas may have a contract with a company in the UK to supply machinery or to maintain that machinery, to build that machinery, and you will see the full list of all of those activities under P7 there. But it's basically that situation where you might have to supply goods and services to people in the UK in respect of machineries and equipment, basically. And PA10, work-related training. Employees of an overseas company or organization may receive training from a UK-based company or organization in work practices and techniques which are required for the visitor's employment overseas and are not available in their home country. And that is the key part. You have to demonstrate that that is not available to you in your home country, which can be a bit tricky sometimes, but doable. And that is it for the immigration section. I had to speed through the last few slides, but hopefully it wasn't too confusing. If any questions arise from that, then please do let us know. And I think Sibylla is coming back now to wrap things up for us.
Well, thank you very much, Hugo, and thank you very much for everyone to listen to our webinar this afternoon. As Hugo said, if you have any questions, please do let us know. Please do have a look at the services that we can offer, link up with us on LinkedIn, and otherwise enjoy the rest of the afternoon and the week. Thank you. Bye-bye.
Thank you, everyone. Bye-bye.